And on Samson's take, the court won't injunct investigations. There have been attempts to injunct investigations started by law enforcement agents. Some of the attempts are to stop the investigations outright. During the vetting process, we just ended yesterday with Supreme Court nominees. One of the judges, Justice Akabuafu, suggested that that was not a helpful approach. In fact, he was blunt in saying he doesn't see how that will work. I've been wondering myself what goes into the thinking of those who attempt to stop investigations. It is therefore not surprising that the court's Human Rights Division refused the attempt to injunct the OSP for declaring Ken Ofori-Atta wanted. It's another curious thing that the politicians give misleading information in seeking to do what they call legal education of the populace. That if a court has not given an order expressly, you cannot declare someone wanted, a subject of criminal investigations. That's absolutely wrong. And the more they do that, the more they try to muscle and weaken state institutions that must do investigations and help all of us to keep our collective security intact. We are not a jungle, and it takes the law to hold the scales even. It takes the law to prevent a situation where the fittest survive in society. By the time a state agency or law enforcement is declaring somebody wanted, they would have secured a warrant. A warrant is to look for them and arrest them. They're looking for a human being. They're not looking for an animal or an item. They must not look for them in the secret. They will search for them in the open. Partly the purpose of Interpol, if they can't find you around within the jurisdiction, they can escalate that. So they put you on a certain notice for the entire world to help to find you. Warrants are issued partly for that purpose. And we declare people wanted because they are fleeing and we can't find them. So when you say they cannot declare them wanted, at what time should anybody be declared wanted? It will be at that phase. So it was very refreshing to hear the judge say that that appears to be a very wrong approach, which will not yield any results. We are insisting that some people should be treated differently with what you call trial in absentia. Yes, trial in absentia can happen. The Constitution provides that it can happen. But guess what? The Constitution says it must happen under two conditions. Where the person has absconded, the one you are looking for, has absconded, has run away. 2, where the person has made it impracticable for the trial to happen in their presence. So the default position of the law is that the trial must happen in the presence of the person. And guess what? It says trial in absentia must happen when the person has been charged. If you have not been charged with an offense, you cannot be put on a trial in absentia. How do you get charged? You get charged through an arrest, or call it invitation, which may come into the same situation of arrest, or that a summons is issued by the court for you. Charges are preferred. You are required to give a caution statement and a charge statement. The Constitution says it is only after this that we can try you in absentia. If you abscond, like Benjilo and his friend did, 2 of them out of the 5 who were put in trial in 1994, was it? 99. They escaped. The trial happened because they had been charged. Sedina Tamaklo Atieno, she was charged, former Maslog boss. She was charged. She ran away. Trial happened. She was already charged. So let's give the people the right education and not mislead them. This will be my take. And watching the vetting process, one very refreshing thing to me was that I saw about 2 of the judges whose names were up in 2023 for appointment. Justices Efia Sewa Asareboche and Eric Che Bafo, they were there supporting their friends who have been nominated now. It was beautiful. And that will be my take.